Welcome to the Tenant Law Podcast. I am Michelle Itkowitz. The New York State Legislature just passed Good Cause Eviction. This is the most significant change in landlord-tenant law that I have seen in the 30 years that I have been a landlord-tenant litigator in New York City. What is good cause eviction and why should you care? Well, that is what we are going to be covering as we begin Season 2 of the Tenant Law Podcast. First, as always, let me give you some context. In New York State, we have a statutory system called the Rent Stabilization Law. We've talked about that a lot on this podcast. If you are rent stabilized, that means your rent can only go up by small increments governed by certain rules. You cannot be evicted unless there's a good reason for your eviction, such as you're not paying the rent without justification, you are violating the lease, or you are committing nuisance. Rent-stabilized tenants have extra methods for enforcing their housing rights at the New York State Division of Housing and Community Renewal, the DHCR. So when compared to non-rent-stabilized tenants, rent-stabilized tenants have many more rights. Rent stabilization applies to about 1 million apartments in New York City and was enacted in the early 1970s. But that still leaves another 1 million apartments in New York City that up until Friday, April 19th, 2024, when they passed good cause eviction, were considered to be what we call free market. In a free market apartment, the landlord is able to raise the rent as much as it wants to or to freely evict the tenant. Now, that does not mean that there are not certain protections in place that slow down the process of eviction for free market tenants. For example, a landlord cannot evict a free market tenant for a discriminatory reason, and there are notice requirements before a landlord can terminate a month-to-month tenancy or raise the rent more than 5%. Also, a landlord cannot attempt to evict a free market tenant in retaliation for the tenant complaining about bad conditions in the apartment. But those protections for free market tenants do not amount to what rent-stabilized tenants have, and that is an apartment that you cannot be evicted from as long as you pay the rent, which only goes up by so much. In other words, really, a rent-stabilized apartment is a home for life. A free market apartment doesn't really work that way. So in other words, up until last Friday, about half of the tenants in New York City were basically protected from eviction without cause, and half were not. Enter stage right, good cause eviction. Now many, not all, but many, we're going to cover who's covered. Now many, not all, free market tenants have been converted into what I'm going to call good cause tenants. And now these good cause tenants have a type of protection against certain rent hikes, and they can only be evicted for good cause. The best way to think about it is like this, because I really want you to understand the context. I want you to understand where good cause fits. If you don't understand where we already are, you're not going to understand where it fits. So the best way to think about it is this. We now have 4 major categories of housing in New York City. There are actually more than 4 types. We have 4 biggies. And I'm just trying to give you a way to put good cause in perspective. So let's look at the 4 categories. Now we are going to have some tenants who are still going to remain free market. We just talked about that. And we have rent stabilized tenants. Nothing's changing about that. We just talked about those tenants. Then there's a large category of tenants in New York City who are in affordable housing. And in that category, I'm putting anybody who's in the New York City Housing Authority, which has about 40,000 apartments, or anybody who is in any kind of private government subsidized project where your housing is needs-based. Eligibility for that housing, for affordable housing, depends on tenants' income and assets being below a certain threshold. That's a huge distinction because rent stabilization and good cause, the new thing, good cause, they're not needs-based. You could be a millionaire and be living in a rent-stabilized apartment, and occasionally you see just that. And the same is going to be true for a good cause apartment, not needs-based. Thus, the new kid on the block of these 4 big types of housing is good cause eviction, which, as I'm recording this, is not even 72 hours old. Good cause tenants are similar to rent stabilized tenants, but there are also some very big differences, and we're going to cover those differences. For now, suffice it to say that the good cause eviction law is an entirely separate statute, an entirely separate law from the rent stabilization law. Now, I must read the new law very carefully. I'm walking around with a dog-eared copy of the good cause eviction law. I have to do this because this is what I do for a living. Usually when something huge changes like this, I write a comprehensive article and I put the article on my law firm website. This time, I'm going to share my analysis and insights about this new development about good cause eviction law here on this podcast. We will be learning about good cause eviction together. And if you stick with me, you're going to learn about good cause eviction in far greater detail than you're going to get almost anywhere else. I can tell you how different sections of the good cause eviction law are likely to play out, where the big fights in the courts are going to be, and where the good cause eviction law actually falls short and leaves us with some unanswered questions. I don't know how many episodes of the podcast this exploration of the good cause eviction law is going to take. We're going to play it by ear, and I'll make sure that no episode is not much longer than 20 minutes. This is what we are going to be working on here and the beginning of season 2 of the Tenant Law podcast. So let's get down to business. Let's start with logistics, because I always want you to know where you can find the law so you don't have to just read about it in the press or on some website and have somebody tell you what it says. If you want to look at it, you can look at it. On April 19th, 2024, the New York State Legislature passed and the governor signed into law a bill called S-08306C. That was a very large document. It was like 200 pages because it was the governor's entire budget. And the part that concerns us is part HH, Good Cause Eviction Law. And the way it works is the bill amends existing laws. So we have the real property law here in New York. And the bill amends the real property law, and it amends some other laws as well. But basically, it amends the real property law, and it does it by adding an entirely new section called Article 6A, Good Cause Eviction Law. It has 8 sections. One section at 212 tells us applicability in the city of New York. It tells us that this law is applicable in the city of New York. Nothing else has to happen for this law to apply to New York City. Whereas Section 213 is about the voluntary participation of local governments outside of the city of New York. So other municipalities have to decide whether they are going to opt into this law and adopt it. All right. The meat of this law is in Section 215, Real Property Law, Section 215 and 216. So there are 2 major aspects to every regulatory law. First, you need to know what the law does. What does it prevent? What does the law require? What protections is it giving you? What restrictions does it put on you? Second, you need to know if the law applies to you. Does good cause eviction law cover your apartment? And if so, why? And if not, why doesn't it? Are you sure it doesn't cover your apartment? Today, we're starting with the first aspect. What does this law do and how does it do it? So we start at Real Property Law, Section 215. I'm going to read you a sentence. I'm sorry, as I always tell you guys, the law is words. I took out a lot of the chunky words in the middle and I put a few things in brackets and made them simpler. So I'm reading, this is basically the essence of the law. Real Property Law 215. No landlord shall remove any tenant from housing accommodations covered by this law except for good cause, as defined in this law. That's huge. Let me just read it one more time. No landlord shall remove any tenant from housing accommodations covered by this law except for good cause as defined in this law. So what's good cause? Real Property Law Section 216 tells us what constitutes good cause. It tells us the grounds for removal of a good cause tenant. But first, Real Property Law 216 notes that the prohibition against eviction without good cause applies even if the tenant never had a lease or even if the lease has expired. So it's not a lease-based program. No lease, your lease expired, you could still be a good cause tenant. So here are the reasons that a good cause tenant can be evicted. The first one is found at Real Property Law 216A. Failure to pay the rent. You can be evicted to fail to pay your rent. But, and this is a big but only if the rent you owe did not result from an unreasonable rent increase. Well, what's an unreasonable rent increase? The Good Cause Eviction Law defines unreasonable rent increase as any increase that's more than something it calls the local rent standard. So an unreasonable rent increase is more than the local rent standard, but what is the local rent standard? Well, the Good Cause Eviction Law also defines local rent standard. Stick with me. The local rent standard changes annually, and it is either no more than 10% or 5% plus the percentage change in the consumer price index. I got to admit, I didn't even know what the consumer price index was before I had to engage with this statute. And I'm still not sure I know what it is, but I just know that it exists and you can find it on the internet, and the state is going to publish it in a place where it's convenient for everybody to see. So we will always know what the local rent standard is. So the percentage increase in a renewal rent is going to be somewhere between 5 and 10%, and it's going to change every year based on the CPI. Okay. All right. So let's just do that one more time. You can be, if you're a good cause tenant, you can be evicted for failure to pay your rent, but only if the rent you owe is not the result of an unreasonable rent increase. And an unreasonable rent increase is anything that is more than the local rent standard, which is a percentage that is going to be established with some relationship to the change in the consumer price index, but never more than 10%. So that is a cap of sorts. And any increase over the local rent standard, the statute tells us, is presumptively unreasonable. Okay? But this is where it gets tricky. Just stick with me. That cap can be overcome by the landlord. In order for the landlord to overcome the local rent standard limit, it would need to provide a special notice to the tenant in a timely fashion of justification for attempting to charge a presumptively unreasonable rent. Now, that justification may include, but it is not limited to, things like fuel costs, utility costs, insurance costs, maintenance costs, taxes, the cost of significant repairs that are not needed because of the landlord's failure to maintain the building. It can also include costs for structural work, electrical work, plumbing work, work on mechanical systems, or the abatement of hazardous conditions, but not cosmetic improvements. Okay, that is very different than what I'm used to with rent stabilization. With rent stabilization, we're used to guidelines board increases, and we know how much you can take for a 1-year lease and how much for a 2-year lease. By the way, this doesn't say anything about 2-year leases. So I don't even know what to do with that. Let's put that on the side as a question for now. Okay, so here we are going to get a percentage rent increase cap, but the landlord can justify overcoming that cap with all these, by evoking all of these other circumstances: fuel costs, taxes, structural, mechanical. Okay, let's just play it forward. What happens if, after receiving the proper notice, you as a good cause tenant do not agree with the landlord about this presumptively unreasonable higher rent? You don't agree to pay it. What happens? Well, we're going to jump down now to Real Property Law 216, Section J, and it tells us that another basis that the landlord can refuse to, another basis upon which the landlord can attempt to evict a good cause tenant is because the tenant refuses to agree to a reasonable change in the lease. And this would be the issue. Is this rent increase that's presumptively unreasonable because it's above the local rent standard, is that reasonable or is that not reasonable? So, good cause tenants, and this is me now with commentary. Good cause tenants have no mechanism for challenging a presumptively unreasonable rent increase other than to refuse to agree to pay the rent above the local rent standard increase and then I guess get sued in a holdover. There's no agency like in DHCR for rent stabilized tenants. You can go to DHCR and vet different landlord actions, but there's nothing like this here, and that seems to me very unfortunate for tenants. In the realm of repairs, I always tell tenants it's better for you to pursue remedies to get your repairs by going after the landlord at DHCR, at HPD, in an HP action in housing court. Don't like when tenants withhold rent and then get sued by the landlord when they need repairs, because I've always thought it's so unfair that somebody would have their rights are being violated, and so the only way to enforce them is to let themselves get sued. That never sits right with me. And in this whole good cause eviction statute, it seems to be the whole way it's set up is a tenant's only ability to enforce their rights here is to end up getting sued. It's illegal in New York for future landlords to consider whether you've been sued in the past. There's an anti-blacklist law, but as of reality, who wants to get sued? Not just because you don't want your name in the public record, but it's a hassle. It's expensive. It takes time from work. Here's my other comment. Let's keep playing it forward. This is going to create so much more litigation in the housing court, which will be very technical in nature. For example, I came up with an example. Let's say the landlord says, I must have a 16% rent increase because of required structural work on the building. And after proper notice from the landlord, the tenant refuses such increase as presumptively unreasonable. Then the landlord sues the good cause tenant under Real Property Law 216J for failure to agree to what it deems a reasonable change, stating that the landlord has overcome the presumption of unreasonable rent. Now, what does that trial in housing court look like? The landlord's claim was based on the need for structural work. So that's going to require expert testimony. The landlord has to bring, who knows if something needs structural work? You need an engineer for that. So the landlord must have an engineer if they're doing structural work. So the landlord's going to come in with their engineer who's already on their payroll. What's the tenant's next move? Does the tenant need to go out and drop $10,000 on a structural engineering expert to testify? And this could be very technical and very expensive litigation, not to mention, how is a housing court judge supposed to decide how much more rent a particular individual tenant is going to need to pay because a landlord has some kind of building-wide issue like increased fuel costs or increased taxes or structural work or plumbing or whatever? What if the landlord is only charging that one tenant more? Do we know if the landlord is charging all of the tenants more to make up for this work? I mean, I got questions. So let's take a break and come back and look at the rest of Section 216. Did I end that last segment on too negative a note? I didn't mean to be a big downer about good cause eviction. This is going to be great for many, many tenants. But look, I have questions. And this is how we engage with the law. We have questions. They make a new law. We question it, we fight about it in the courts, and then they make another new law. So that's our process. And here's the thing. Here's my perspective. And I don't want to do too much of my perspective, but it's what I'm doing with the podcast. That's why I'm telling you. Tenants in New York have more rights than they do anywhere else, and that's great. But again, what do I always say at the end of every podcast? Your ownership of the law is only as great as your understanding of the law. I get so many calls and emails every year. People don't know they have rights. And if they do know they have rights, they don't have the wherewithal to enforce them a lot of the time. That's really the problem. It's not about more rights. It's about enforcing the rights that people have. So I figure the best I can do is offer a free podcast where I don't dumb it down. And I'm really giving it to you so you understand what's going on. And the more you know, the better off you're going to be. Let's do the housekeeping. This is not legal advice, and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it is legal advertising, it is terrible because I am asking you not to contact me. Please don't contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Email us with your questions to answer on the pod. If you like our work, please give us 5 stars and put this podcast on your socials, etc. Let's continue with looking at the other reasons a good cause tenant can be evicted, which are the balance of real property law, section 216. Now, I am about to read you a list of 8 other reasons you can be evicted if you're a good cause tenant. And it's going to sound like a long, scary list, but you should not be scared of it in the least. And I will tell you why at the end. A good cause tenant can also be evicted for violating a substantial obligation of their tenancy after 10 days notice to cure, for nuisance, for maliciously or by gross negligence damaging the building or by interfering with the comfort or safety of the landlord or other tenants, for causing a government violation, for using or allowing to be used the apartment for illegal purposes, for unreasonably refusing access for repairs or other reasons the landlord needs to show the unit. Good cause tenants can also be evicted if the landlord seeks in good faith to recover the apartment for landlord's own personal use or that of landlord's family, but this does not apply to tenants 65 years or older or disabled tenants. Good cause tenants can be evicted if the landlord seeks in good faith to demolish the building or if the landlord seeks in good faith to withdraw the apartment from the housing market. That might sound like a long, scary list, and you might, if you're not familiar with this stuff, you might say, oh, wow, that's a lot of reasons the landlord can try and evict me if I'm a good cause tenant. But all of these reasons are also contained in the rent stabilization law. And I can tell you, after 30 years in housing court, working with rent stabilization, these bases for eviction result in very, very few evictions. The courts abhor a forfeiture. They generally would like to see people stay in their homes, especially if they have rights to not be evicted without good cause. And, some of these things, I haven't seen a case under rent stabilization for owner's use, and I think about 5 years. Maybe I've seen 1 or 2 in the New York Law Journal. Because look, if a landlord has a mansion in Great Neck and they're saying, oh no, I really want to live in your studio apartment in Hell's Kitchen, no court is going to believe that. But some of these bases, it's important that they're in there. For instance, nuisance. Occasionally you get a tenant who is torturing other tenants in the building, and you want a mechanism to be able to get that tenant out. So these reasons, there's no surprises here. Landlord-tenant lawyers expected to see all of this, and there's nothing very concerning there. The real interesting part of the statute is what we covered before the break in terms of the rent cap that's not really a rent cap, and all the litigation that's probably going to be around that topic. And there you have it. In the next episode, we're going to tackle figuring out which tenants are covered by good cause eviction, and I hope to get you that in a few days. Another idea I had, because Spotify is now taking away my baby podcaster widget for making podcasts and forcing me to learn to use Riverside, which I'm actually pretty excited about. It's got a lot of features. And one of the features is I'm going to be able to do interviews. So I'm hoping to try to I'm thinking of a very experienced landlord lawyer and a very experienced tenant lawyer who are my frenemies. They're my adversaries, but I respect them. And I'm hoping to maybe get them on the podcast for an episode where we talk about the law, and I'd love to hear their impressions. So stay tuned for that. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.